For hearing, item number 11.
May it please your Lordship, before entering into the facts of the case, your Lordship, I would like to take your Lordship's attention to one judgment which squarely covers this case, which is
Carefully supplied earlier also.
here is one of the previous
There is one judgment here, Avishe
yes, this is the one.
WP40.
The facts are exactly same. Land also, the land, the dispute involved here, the land area, it is also same. Only the parties are different. Here the petitioners are a group of villagers. Otherwise the facts are more or less same. If I may read before.
Okay. Yes, WP40.
If I may read it, Lordship, this is heard Mr. City Jamir, learned senior counsel, assisted by Mr. Aliba Ozugam, so-and-so, paragraph 2. The Purana Bazar B Village Council, by an allotment certificate dated 6/6/2006, allotted a plot of land measuring 70 into 72 Shri Mukaho, son of so-and-so. Thereafter, the petitioner purchased a said plot of land from the said Shri Mukaho by executing a sale deed dated 12/12/2010, and no objection certificate was also issued by the chairman of the village council of Purana Bazar B Village Council with regard to the ownership of the land measuring so-and-so by the petitioner. The petitioner made an application for regularization of his plot of land before the Deputy Commissioner, Dimapur, Nagaland, and accordingly, after following due process, the Deputy Commissioner, Dimapur, issued an order dated 25/8/2014 regularizing a plot of land under TAC number 104, measuring an area of so-and-so at Purana Bazar. The TAC number is same, Your Lordship, 104. Purana Bazar in the name of the petitioner. Thereafter, Jamabandi in respect of TAC number so-and-so for an area of so-and-so was issued on 26/8/2014 on the basis of the regularization order dated 25/8/2014 issued by the Deputy Commissioner, Dimapur, Nagaland. The petitioner thereafter was in peaceful possession of the said land. 3. In the meantime, the respondent number 4 filed a complaint dated 21/6/2017 before the Deputy Commissioner, Dimapur, Nagaland, with regard to land dispute at Purana Bazar B village covered by Pata number so-and-so, TAC number 104. In terms of the complaint made by the respondent number 4, the Deputy Commissioner, Dimapur, Nagaland, by a letter dated 23/6/2017 addressed to the head Dobashi of the Office of the Deputy Commissioner, Dimapur, Nagaland, directed them to verify the spot and submit report on or before 30/6/2017. Thereafter, by summon notice dated 17/12/2018, the Deputy Commissioner, Dimapur, Nagaland, directed the petitioner and the respondent number 4 to appear in his court on 12/12/2018, along with all original documents in support of their respective claims. Thereafter, the impugned order dated 17/12/2018 was issued by the Deputy Commissioner, Dimapur, Nagaland, stating that Pata number 1675 was regularized in favor of the petitioner without the approval of the government and in violation of the notification number so-and-so, February 1992, issued by the state government, Department of Land Revenue. It was also stated that the village authority is not empowered by the government to issue land allotment order to any individual or organization under the cadastral area. Accordingly, the order dated 25/8/2014 by which the land of the petitioner was regularized and Pata number 1675 were declared cancelled, as well as the allotment certificate number 73 issued by the Purana Bazar B Village Council was also declared null and void. The surveyor in charge of revenue record was also directed to delete the records in terms of the order dated 17/12/2019. Consequent to the order dated 17/12/2018 passed by the Deputy Commissioner, Dimapur, Nagaland, Eviction order dated 16/3/2019 was issued to the petitioner directing to vacate, dismantle his illegal occupation construction in the land covered by Pata number so-and-so, measuring an area of so-and-so biga at Purana Bazar. Being aggrieved with the order dated 17/12/2018, the eviction order dated 16/3/2019, the petitioner is before this court. 4. It is the case of the petitioner that the Purana Bazar village is a traditional village established in the year 1942. This is very important, which is authenticated by the list of villages, towns, compounds with number of houses and GBs in Nagaland as on 1st April 2002, issued by the Office of the Commissioner Nagaland Kohima, wherein the name of Purana Bazar B village is listed at serial number 16 with 51 houses, 2 GBs, and shown as a recognized village. Learned Senior Counsel for the petitioner has also drawn the attention of this court to a communication dated 25th July 2016, written by the Additional Secretary to the Government of Nagaland and addressed to the Commissioner Nagaland with regard to the recognition status of Purana Bazar B village under Dimapur district, wherein it is stated that the government has examined the detailed report on the status of recognition of Purana Bazar B village and observed that Purana Bazar B village is a traditionally established village, and the department does not issue recognition order or notify recognition of a traditionally or ancestrally established village. He therefore submits that as the allotment certificate issued by the Purana Bazar B village being a certificate issued by a traditionally established authority, there is no requirement for permission from any authority to grant land allotment within its territorial jurisdiction. Therefore, the Deputy Commissioner Dimapur Nagaland had no authority to issue the impugned order dated 17/12/2018, by which the order dated 25/8/2014 and Pata number 1675 were declared cancelled. The further case of the petitioner is that as the land is a private land and not within the ambit of government land covered by notification number LR so-and-so, February 1992, the Deputy Commissioner Dimapur has no authority to issue the eviction order dated 16/3/2019. And if the respondent number 4 has any claim over the land of the petitioner, the only option for the respondent number 4 is to approach the civil court, which has the jurisdiction to try such matters. 5. Ms. Ayemi, learned government advocate, submits that the provisions of Assam Land and Revenue Regulation 1886 is applicable in Dimapur, Nagaland. Therefore, the government has ownership of land. Learned government advocates also submits that a claim of the petitioner to claim right, title, and interest over the disputed land by way of an unregistered sale deed is not deniable in law. She further submits that as the disputed land falls under Dimapur Moza and therefore no allotment of land can be issued by a village authority. The respondent number 3, therefore, after receiving the complaint from the respondent number 4, had heard both the parties and after verification of all revenue records had issued the order dated 17/12/2018 and eviction order dated 16 March 2019. The respondent number 3, having jurisdiction, had passed the aforesaid 2 orders and therefore no interference is called for. 6. Mr. Z.N. Nguli, learned counsel appearing for the respondent number 4, on the other hand, submits that the respondent number 4 acquired the right, title, and interest over the said land by way of a gift deed dated 17/9/2008, executed between Sri Yarendong Lotha and the respondent number 4. Thereafter, Jamabandi in respect of Pata number 1145 so-and-so for an area of so-and-so was mutated and transferred into his name, as the petitioner was encroaching over the land of respondent number 4. He filed a complaint dated 21/6/2017 before the Extra Assistant Commissioner Jammu Kidima. He therefore submits that as the Purana Bazar B Village Council has no authority to issue the land certificate to the petitioner, the very basis over which the petitioner claims title over the land does not survive, and therefore no interference is required in the impugned order dated 17/12/2018 and the eviction order dated 16/3/2019. This particular sentence is very important, Your Lordship. Further, the case of the respondent number 4 is that the Additional Secretary to the Government of Nagaland, by a letter dated 15/7/1985, conveyed the approval of the Government of Nagaland for allotment of land in respect of Dak number 104, block number so-and-so, measuring an area of 195 biga 3 kata 0 lesas to Shri D. A. Nguli and party in which the respondent number 4 is one of the beneficiaries. So here the private respondent is also claiming under this so-called allotment given to D. A. Nguli, Your Lordship. 7. Mr. Limawabang, learned counsel for the respondent number 5, submits that the Purana Bazar village was established in the year 1942 and therefore it is considered a traditional village, and as such, the village council of the said village has the authority to issue land certificate in respect of any parties within its territorial jurisdiction. He, however, submits that in so far as the dispute between the petitioner and the respondent number 4 is concerned, the same being a disputed question of fact, the aggrieved party may be directed to approach the civil court having competence and jurisdiction. 8. Heard the learned counsel for the parties. 9. A consideration of the submission of the learned counsel for the parties as already recorded herein above would clearly indicate that there are serious disputed questions of facts involved in this case, inasmuch as both the petitioner and the respondent number 4 claims right, title and interest over the disputed land. This court has noticed that it was the Deputy Commissioner Dimapur who had recognized the land of the petitioner, and therefore on the basis of said regularization, Jamabandi was issued to him. The respondent number 4 also claims right, title and interest over the said land on the basis of a gift deed dated 17/9/2008 executed between Sri Yarendong Lota and the respondent number 4. And thereafter the land was mutated in the name of the respondent number 4. These claims and counterclaims over the disputed land cannot be adjudicated by this court sitting under Article 226 of the Constitution. It is already a settled principle of law that for right, title and interest over a particular area, it is only the civil court that has competence and jurisdiction to adjudicate the matter. The impugned order dated 17/12/2018 issued by the Deputy Commissioner Dimapur, Nagaland, declaring the order dated 25/8/2014 and Pata number 1675 as cancelled and the allotment certificate number 73 issued by the Purana Bazar B village as null and void is also found without jurisdiction of the Deputy Commissioner Dimapur, Nagaland. Further, in the absence of any proof that the disputed land falls under the government land, the Deputy Commissioner Dimapur, Nagaland could not have issued the eviction order dated 16/3/2019. Accordingly, the order dated 17/12/2018 and the eviction order dated 16/3/2019 are set aside and quashed. The writ petition is accordingly allowed. Liberty is granted to the aggrieved party to approach the competent civil court for redressal of any grievance, if so advised. So essentially, the finding of this honorable court is that the land is village land, and in the absence of any proof that it is government land, the Deputy Commissioner has no authority, no jurisdiction. That is the basis. Now, like I have stated earlier, in the submission of the counsel for the respondent, it so happens that the TAC number 104 is a waterlogged area, especially during the summer, it gets flooded. Because of that, development for development of the land, for filling of the land, it takes time as well as money, Your Lordship. Now the petitioners who are villagers of the village, they were allotted plots of the land, and they were in the process of slowly developing their land when in 2021, during the lockdown 2020, the private respondent, claiming his right on the basis of that 1985 allotment to Sri T. A. Nguli, encroached upon the land. Yes, that same allotment, he encroached upon the land. The villagers resisted. Then what happened was, he filed a complaint before the Deputy Commissioner. The Deputy Commissioner, just as in this case, cancelled the village allotments and also the allotments, the patas granted by his office to some of the villagers, and held that the private respondent who has encroached upon the land has right over the land. And this is how we have approached this honorable court. And so the facts are same. Only the parties are different.
The area is also the
The
same.
land is also same. Dark number 109, because the entire dark number 109 is 195 bighas, above 195 bighas. It is a huge area of land. So in 1985, allegedly, it was D.A. Muli, the former minister, he was allotted that land without informing the village. And then in 2006, he tried to encroach, he tried to put boundary stones on the land, the village resisted. Matter ended there. Then later on, after so many years, again, Pata, the present respondent obtained Pata over the land and then encroached onto it. And the case developed from that day. Now, Your Lordship, I'll take Your Lordship through the facts of the case.
In this case also, there was an eviction order.
Yes, there was. The impugned order is at the last page, but before reaching that, the facts, Your Lordship. Because once it is established that it is village land, then the matter ends there. Before going into the
Your Lordship, sorry to interrupt, Your Lordship, but in my respectful submission, Your Lordship, this petition, I think it has to be heard in 3 stages, Your Lordship. Before my learned friend, he goes to the facts, Your Lordship, that is on the merit. First, whether the issue in the present writ petition will be covered by the judgment passed in writ petition
previous
40 of 2019. That is one. Second, Your Lordship, may I take Your Lordship to the order dated 23/5/2022.
Twenty-three,
2022, Your Lordship. Lordship has found it.
22/5 is there.
22.
22.
23, 5.
22/5, 23
23,
is
2,
there.
3, 2, 3. 2, 3, 23. 23/5/2022.
After 22/5/23, the next order is 6/6/23.
Then 22, Your Lordship, is it
Oh, yes,
regarding?
yes, 23/6 is there.
Yes.
23,
5.
5.
23, 5.
5.
Yes.
Yes, Your Lordship. 23/5. It is there, Your Lordship. 23/5.
Because it is 6.
I think
23/5/23.
no. This is 2022. 23/5/2022. Huh? Yeah, the 9. 23/5. 23/5. This is an order passed by the Honorable Court on maintainability, Your Lordship. Whether this petition will be maintainable under 226 or 42 CRPC or 151 of Assam Land Revenue Regulation 1886, Your Lordship. So, Your Lordship, this also needs to be addressed. First, the petitioner needs to satisfy on this, because there is an order passed by the Honorable Court, Your Lordship. Then only, Your Lordship, in my respectful submission, this Honorable Court can go into the merit, Your Lordship. So there is a specific order passed by the Honorable Court. So, Your Lordship, my respectful submission, first, Your Lordship, whether the issue involved in this writ petition will be covered by the judgment passed in writ petition 40 of 2019. Supposing, if it is covered, then the matter ends there. And if it does not cover, then petitioner will have to satisfy this Honorable Court on maintainability. Then only, Your Lordship, on merit, Your Lordship. So in my respectful submission, it has to be heard in 3 stages, Your Lordship.
But in the cost title, the copy which is available before me, it says application under 226.
Application under 226,
Yes.
and no, and then no. Read with, in my cost title, it is
That is not
482.
there. 482 is not there, 151 is also not there.
No. In my petition, it is there, Your Lordship. Yeah, it is there.
It is there. Your Lordship, but this is essentially under 226, Your Lordship. It was out of abundant caution, this section was inserted.
And why was this deleted?
Sorry?
It has been deleted and
Oh, by the order of the, if I'm not mistaken. First order, just check first order.
then everything is deleted and then
Yes, it must be, yes.
it just says application under Article 226.
Yes, this was one order which was there. One order of this Honorable Court may be there.
Oh, anyway, Your Lordship, then whether it is maintainable,
Yes.
it will be maintainable under
Maintainable
226.
under
Yes,
226. That can be
Your Lordship.
examined, Your Lordship.
Considering the
but
fact that there are
yes.
disputed questions. of
Yes,
fact.
no, otherwise,
Yes.
no, Your Lordship. Whether writ of certiorari will lie against an order passed by a quasi-judicial authority, in fact, passed by a court,
By the DC.
because under Assam Land Revenue Regulation Act, the Deputy Commissioner who acts as Revenue Court.
Lordship, my case is not that,
Since there is an appellate authority also,
but,
Commissioner,
no, there is no appellate authority.
Anyway, Your
there
Lordship,
is
but
under revenue, Assam Land Revenue.
Yeah,
Yes.
but
Commissioners-
I'll take Your Lordship, I'll satisfy Your Lordships by showing that this is village land. Once it is village, it is a recognized village, then the land belongs to the village. So now, the question of the revenue regulation coming into, being applied here does not arise. That is my case. That is my case.
in my respectful submission, Your Lordship, if Your Lordship may
But in
first heard.
WP 40 also, the
Yes.
court never said that it is village land.
No, the court has held that, so as long as the government cannot prove that it is village land, that is what the court has held, Your Lordship.
So if the issue as to whether the present writ petition will be covered by
Your Lordship, may I
judgment.
come to the last page, that is further.
The absence of any
In the
proof.
absence of any proof that the disputed land falls under the government land.
But the petitioner.
So there is absence. Here, the government has not, the matter has come to an end. This has attained finality. No bill was filed by the government. The government could not show that it is government land. It is village land, and I'll take Your Lordship to the map also. Because the map which is prepared by the state government, which is in their, on their records, it clearly shows that it falls under the village land.
Okay.
If it is village land, then the Assam Revenue Regulation has no application. That is my only case here.
So regarding you submit on the maintainability first then?
So once, yes,
Yes.
I'll prove to Your Lordship that it is village land. I'll take your lordship to my petition. Paragraph 2, these are the facts which are the basis on which my...
Yes, your
Paragraph 2, page 11, your lordship. Paragraph 2.
Yes.
That all the petitioners are allotment holders of plots of land in Dak number 104, Purana Bazar B village, Dimapur, which is the subject out of which has arisen the issues involved in the instant petition. In this regard, the petitioners beg to highlight the following pertinent facts regarding the status of the land in question. Number 1, that the Purana Bazar B village is a traditionally established state-recognized village. The village was established in 1942. In 1963, when Nagaland attained statehood, it was declared as ancestral and traditionally established village of the state. The village was originally named Pukajan, but in 1972, when the survey map of the village was prepared, the authority decided to put the village name in the map as Purana Bazar, so that the village may not be identified as a village of neighboring Assam. Subsequently, in 1982 to 83, when the government started releasing village development fund to the village, the fund was released in the name of Purana Bazar B. Thus, the name of the village became officially recognized as Purana Bazar B. The history of the village is to be found recorded in the Platinum Jubilee Souvenir 1942 to 2017 published by the village, and the petitioners crave leave of the Honorable Court to produce the same at any time of the proceedings of the present case if deemed necessary. The fact that the village is a recognized village may be ascertained from the list of villages, towns, compounds with number of houses and GBs in Nagaland as on 1st April 2002, published by the Office of the Commissioner Nagaland, wherein the village is listed under EAC Jumukutima Circle in serial number 16, also in 2004. The Deputy Commissioner by letter number so-and-so, dated 22/3/2004, forwarded to the Commissioner Nagaland the list of recognized villages under Dimapur district. And in it, the Purana Bazar B village is listed in serial number 8, showing the year of its establishment as 1942. Further, in 2016, when the village applied for a government recognition order, the Government of Nagaland Home Department General Administration Branch, white letter number so-and-so, dated 25/7/2016, clearly held that the Purana Bazar B village is a traditionally established village, and therefore, the department does not issue recognition order or notify recognition of a traditionally or ancestrally established village. It is deemed recognized, in short. 2, that during 1971 to 72, the administration conducted mapping survey of the entire village area, and a scale map of the village was prepared. As stated herein above, though the original name of the village was Pukajan, the state authority titled it as Purana Bazar. In the survey map, later again in the year 1980s, when the government started releasing VDP fund to the village, the fund was released with the village name as Purana Bazar B. The map so prepared is to be found in the official record of the district administration. A copy of the said map was also made available to the village authority, and the same is still available today. The map clearly demarcates the entire area of the Dak 104, which is the land in question in the instant petition, and it is to be seen that it lies situated in the middle of the village. It is not on the boundary also, it is in the middle itself. 3, that the Nagaland Village and Tribal Councils Act of 1978 clearly lays down in the explanation to Section 3 as follows. Explanation: village means and includes an area recognized as a village as such by the government of Nagaland. An area, in order to be a village under this act, shall fulfill the following conditions, namely: A, the land in the area belongs to the population of the area or given to them by the government of Nagaland. If the land in question is a government land or is given to them by the lawful owner of the land, and B, the village is established according to the usage and customary practice of the population of the area. So the Village Council Act of 1978 clearly says that the land, if it is government land, and it falls under the village jurisdiction. It is the land of the village, and it belongs to the population of the village. Here, government has land only in respect of Dimapur area. In the cadastral area of Dimapur, they don't have private lands in other parts of Nagaland. So here, because of the fact that there are villages established down there in Dimapur, the Act itself has made it very clear. So this is village land.
So how did the
Now-
petitioners also get the land through allotment
By the village.
by the village?
By the village initially, and in order to fortify their rights over the land, few of them approached the Deputy Commissioner's office for Pata. I'll take your lordships to that. Not all the petitioners, few of them. But the initial allotment was the village allotment.
Then
Now, the Act thus makes it clear that the land in the area belongs to the people of the village. This being the legal position, the land that is TAC number 104, which is entirely situated within the Burana Bazar B village, undoubtedly belongs to the Burana Bazar B village. No doubt the Burana Bazar B village falls under cadastral area, but the fact that it is a government-recognized village itself is proof that the land falling under the jurisdiction of the village is land given to the village by the government and recognized as such by law. And as such, the government cannot subsequently allot any portion of it to a third party without consent and approval of the village. 4. The TAC number 104 is a waterlogged area of land measuring 195 biga, 1 kata, 3 lisas. In 1973, the Burana Bazar P Cooperative Joint Farming Society Limited, consisting of members of the village, applied for settlement of the TAC number 104, and the 10th Subdivisional Officer Civil Dimapur, by order dated 22/3/1973, allowed temporary settlement of the said land to the society, pending finalization of the map. Pending the finalization, the map survey had been conducted, but since the map had not been finalized, it was temporarily allotted to the village farming society. Now, before going further into the other aspects, I'll take your lordship to the map itself, because this is not a map prepared by the village arbitrarily. It was surveyed, and the map is there officially before the revenue office also. Annexure P. Annexure P is a huge map. So the TAC number 104, your lordship, it's in the middle of the village. 104. This is the entire area of the village, and 104 is in the middle. If your lordship may see, it's a huge plot of land. So when all these other surrounding areas are village land, this 104 cannot be. Belonging to others.
these are all dark numbers, isn't it?
Yes, TAC number 104. 104
The
is
others
that.
also.
Yes.
The other dark surrounding it.
Yes. 132, 133, 104, all these are TAC
68,
numbers.
69.
Yes. So this map is verified by a surveyor, officers, and this is to be found in the official records of the Revenue Department at Dimapur. This is just a copy which was furnished to us. So there is no dispute regarding this map. Now, Annexure A, these are the list of villages, towns, compounds with number of houses, chibis in Nagaland as on April 2002. This was published by the additional, this was forward is by the Additional Chief Secretary and Commissioner Nagaland. Here, page 42. Page 42. This is under the Jumu EAC, Jumu Kitima Circle, page 42. The first, that is serial 16, but it is first list. Purana Bazar B, recognized, recognition, unrecognized, recognized, unrecognized. This is a recognized village. Now, page 47. Page 46, Annexure A2. Annexure A1 is the list of towns, compounds issued by the government. Then, page 46, that is Annexure A2. The typed copy is page 47. Submission, this is Office of the Deputy Commissioner, Dimapur. Submission of list of recognized village under Dimapur district. With reference to the subject cited above, refer to forward herewith the list of recognized village along with the year of establishment of the recognition. This is for favor of your kind information and for necessary action. Now, your Lordship will see this under page. Page 46. Serial number 8, Your Lordship.
Serial
Page
number
51.
8.
Page 51 is the type copy. Yes. This should be under Dimapur. Your Lordship will. Sorry. At page 53, serial number 18, page 53, the typed copy.
Serial number?
Page 53, serial number 18. Purana Bazar B. Year of establishment before the British period, 1942. This is not a recently established village. Now, Annexure A3 is the letter issued by the state government. Page 54 is Annexure A3. The typed copy it is not clear, so the typed copy is at page 55. This is Government of Nagaland Home Department, General Administration Branch, to the Commissioner Kohima, Nagaland. Matter relating to recognition status of Purana Bazar B village under Dimapur district regarding, sir, I am directed to refer to your letter number so-and-so, dated 28/6/2106, on the subject cited above, and to state that government has examined a detailed report on the status of recognition of Purana Bazar B village, submitted by district administration, and it is observed that Purana Bazar B village is a traditionally or ancestrally established village. Therefore, in this connection, it is to state that this department does not issue recognition order or notify recognition of a traditionally or ancestrally established village. This is for your information and further necessary action, please. So, in case of traditionally established villages, it is deemed recognized. The question of issuing recognition to the village does not arise. That is what the order simply says. Now, page 57, annexure C. As I have stated in my petition, the entire survey of the village, the survey was conducted in 1971 and 72. But then the map was finalized only subsequently in 1973, after 73 only. So in the meantime, by this order, which was issued by the Office of the Subdivisional Officer Civil Dimapur, the TAC number 104 was allotted to the Purana Bazar, to the Cooperative Joint Earning Society Limited Dimapur, pending finalization of the map. That is,
So if it is village land,
yes,
why the SDO civil has allotted?
prior to, because of the non-finalization of the map, in the meantime, it was allotted to this group, but pending the finalization of the map. Temporarily, it was allotted to this group. And then subsequently only the map was finalized. And this is the map which I have annexed, annexure P. Now the other annexure T series, all these are the allotments of the village and so allotments by the village, and then subsequently in the case of some of the petitioners, they applied for pata from the district administration, they obtained. In some cases, village allotment itself, the parties did not pursue for further pata from the district administration. So I'll take your lordship to the statement itself, because I have made it very clear in the statement which petitioner has applied for and then obtained the pata. All those I have. Page 15, paragraph 5. That with the steady growth of the village population, the village council allotted portions of the TAC number 104 to the villagers, and the petitioners are also beneficiaries of the village allotments. Among the allottees, those who expressed desire to also obtain pata from the administration as a measure of security were granted permission by the village council to do so. And accordingly, they have applied for and obtained government pata. The petitioner number 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14, 15, 16, 17, 18, 20, 21, 22, and 70 have also obtained pata from the revenue authority. In this manner, and paying land revenue regularly. Many of the allottees have already developed their allotments and constructed residential buildings, while the petitioners are in the process of development of their allotted plots, which is a slow process for the fact that it is an expensive undertaking requiring earth filling. So, these petitioners, among the petitioners, 1, 2, 3, 22 of them, after getting no objection certificate from the village issued no objection, so based on that, they have applied for and obtained the pata from the district administration. And the rest of the petitioners, they have not applied for any pata.
Yes.
So your lordship, the patas are there. If your lordship may want to go through it, I'll take your lordship through the various patas and but then the statements, I believe it will suffice. Now, I'll take your lordship to the next paragraph. Paragraph 3. That in 2006, Shri D.A. Nguli, ex-finance minister Nagaland, encroached into the Tak number 104 by erecting boundary pillars, claiming that he had been allotted the same by the government way back in 1986. When this happened, the Purana Bazar B Village Council and the villagers offered strong resistance to protect their village land, the fact of which is evidenced by the newspaper publications of reporting on the issue. Open letter to the government and notices issued by the village council essentially to the effect that the so-called patta in favor of Sri D.A. Nguli was null and void, as the same was obtained by him without knowledge or approval of the concerned village to which the land legally belongs, and that the village would not allow any person to encroach on their land. The then Deputy Commissioner Dimapur, Shri N.K. Nguli, who reportedly is the brother of D.A. Nguli, tried to intervene in his support by issuing order dated 6/4/2006 to the effect that the land was allotted to D.A. Nguli, ex-minister by the government in 1986, and that anybody found encroaching and developing any portion of the same shall be dealt with serious action. And he even went to the extent of making statements that there is no recognized village named Purana Bazar B. However, the villagers prevailed and Shri D.A. Nguli withdrew from taking possession of the Tak number 104, and the district administration also refrained from any further action on the matter. Thus, the village returned to the peaceful enjoyment of the Tak number 104. It may be stated herein that the then Deputy Commissioner Dimapur order was void ab initio, being not in consonance with the provisions of the Assam Land and Revenue Regulations 1886. And also the Nagaland Village Council Act, which I have also made specific statements, but paragraph 4, that it is a fact that the allotment made in favor of D.A. Nguli was made without knowledge and consent of the Purana Bazar B village and without following the procedure laid down in the relevant law, that is the Assam Land and Revenue Regulations 1886. Under the relevant law, the revenue officer must first determine whether a particular land is liable to be assessment, and only upon finding that it is liable to assessment, proceed for settlement of the land. In a proceeding for settlement, it is mandatory for the settlement officer to offer the settlement to such persons as he finds to be in possession of the estate and to have a permanent, heritable and transferable right of use and occupancy in the same, or to be in possession as mortgages of persons having such a right. Thereafter, only if the settlement officer finds no person in possession, it shall be in his discretion to offer settlement to any person he thinks fit. In the instant case, the Tak number 104 is village land of and in possession of Purana Bazar B village and is not liable to assessment and settlement. Even assuming but not admitting that the land is liable to assessment, it was incumbent upon the revenue officer to offer the settlement to the Purana Bazar B Cooperative Joint Farming Society Limited, which was allotted the land by the sub-divisional officer Civil Dimapur by order dated 22/3/1973, or to the Purana Bazar B village, which is the owner of the land, but without following the prescribed procedure of offering the settlement to the actual possessor. The land was surreptitiously allotted to Sri D.A. Nguli, who was not and had never been in possession of the land. Hence, the allotment was void ab initio. Further, beside the fact that the allotment was illegal, Sri D.A. Nguli never took physical possession of the land, and the land has all along been in the possession of the Purana Bazar B village. Sri D.A. Nguli also did not take any legal steps to take possession of the Tak number 104 subsequent to his eviction from the land, and thus even his right to file suit before the appropriate court of law also became barred by limitation. 5. That while matters stands thus, the respondent number 4 and 1 Srimati Kuholi Achumi claiming to have obtained ownership over the Tak number 104, it should be, through Sri D.A. Nguli, encroached into the land with thumpers and machines, JCB, and started whole-scale earth-filling work in the all the areas of the TAC number 104, where no buildings have been constructed. Therefore, on 21/2020, the petitioners and others gathered at the spot and immediately stopped the ongoing work and compelled them to vacate the land with their machineries. 6. That against the Burana Bazar B village action of forcing them to vacate the TAC number 104, Srimati Koholi Achumi filed an FIR dated 21/2020 before the East Police Station, Dimapur, naming the petitioners number 1 and 21 as the accused, who allegedly with their men, servants and agents prevented her from entering upon the land. Accordingly, the police summoned the petitioner number 1 to the police station, and upon signing a good behavior bond, he was released. Srimati Koholi, having taken up the issue with the police, the villagers decided to take up the matter against her legally with the district administration, and to this end, 24 of them who are petitioners herein, who possess village allotment certificate as well as valid government patta in the TAC number 104, submitted a joint complaint dated 23/1/2020 before the Deputy Commissioner Dimapur, informing him about the illegal encroachment by the husband of Srimati Koholi Achumi and requesting him to pass a restraining order against the encroacher. In this case, Your Lordship, in this case, Srimati Koholi Achumi has approached the civil court at Dimapur, and the matter is pending before the court. The other person who encroached together with this Srimati Koholi Achumi is the present present private respondent. He also encroached on another area of the land. So in this case, the villagers prevented him. What happened was, he approached the Deputy Commissioner, and then
And in that civil suit, you are also parties.
Yes, we have been made parties in that civil suit. We had to approach this honorable court by way of a writ petition, and this honorable court, during the pendency, again, the plaintiff in that case withdrew the case and then again filed afresh, so that the matter is still pending before the court. So here, paragraph 6, the first incident was 21/2020. On 21/2020, all this, the present private respondent and the petitioner and the other person who is Srimati Koholi Achumi, they encroach upon the land on the same day only. So, paragraph 7, the Deputy Commissioner directed the husband of Srimati Koholi Achumi to refrain from undertaking any development works immediately until the matter is settled by the appropriate authority. Then, paragraph 8, summons was issued to all the parties. Then, paragraph 9, that it is pertinent to state herein that Srimati Koholi Achumi also filed a civil suit registered and numbered as civil suit number 1 of 2020 before the Court of Civil Judge, Senior Division, Dimapur, Nagaland, impleading the petitioners number 1 and 21 as defendants, seeking a decree for declaration of rights and title to the land and perpetual injunction, restraining the defendants from disturbing the plaintiff from developing the land. The said two petitioners have filed written statements in the suit, and the same is pending before the said court. So, at the time this writ petition was preferred, that civil suit number 1 was pending. Now, what happened? The plaintiff in that civil suit during the pendency of this case itself withdrew the suit. Then later again filed a suit impleading petitioners. The present petitioners are also there. So that civil suit is still pending before the lower court. Now, 10. That surprisingly, while matters stands thus, the respondent number 4 again encroached upon the TAC number 104 with a large group of laborers and started erecting thatch houses therein. When the villagers confronted him, he produced a restraining order, white number so-and-so, dated 14/10/2020, issued by the Deputy Commissioner Dimapur. A perusal of the order reveals that it is a vague order purportedly issued to some individuals, groups, who are alleged to have been obstructing the respondent number 4 from working on the land covered by Pata number so-and-so, dark number 104, situated at Purana Bazar. Further, the order is not signed by the issuing authority. The order was also issued without complying with the principles of natural justice. The copy of the respondent's number 4 application dated 5/3/2020, which only recently was made available to the petitioners upon request, also mentions that some unscrupulous man has been causing undue obstruction and illegally disrupting the peaceful enjoyment and ownership of the land in question. So again, on 14/10/2020, the present respondent attempted to encroach on the land, producing a restraining order issued by the Deputy Commissioner. Paragraph 11, that the petitioners respectfully state that they could not obtain a copy of the Pata issued in favor of the respondent number 4, but they have been issued a copy of the relevant page of the revenue record, wherein is entered the Pata number, name of the respondent number 4, dark number, and the area of land. The record reflects that the area of land mutated in favor of the respondent number 4 is 34 bighas, and the said mutation has been effected from Sri Kukkohi Awomi, who in turn had affected mutation from Srimati Sanu Nguli, wife of T.A. Nguli, who, as stated here and above, had made an attempt to take possession of the land in question in 2006, but prevented to do so by the Village Council Purana Bazar B. 12. That it is pertinent to state herein that sometime in the early part of 2006, Sri Kukkohi Awomi approached the Village Council Purana Bazar B requesting issuance of a no objection certificate to enable him to purchase the land in question from Srimati Sanu Nguli, wife of T.A. Nguli. But the Village Council refused to issue the same. The Village Council then, under the chairmanship of Let Tokiho, also cautioned him not to purchase the land, as the land belongs to the village, and that Sri D.A. Nguli had attempted to take over the land in 2006. But the villagers had not allowed him to take possession of the same, and he had never staked any claims over the land since then. Thereafter, Sri Kukkohi Awomi also made no further move with regard to the land in question. 13. That aggrieved, at the order dated 14/10/2020, the petitioner submitted before the Deputy Commissioner Dimapur a representation dated 31/10/2020, contending essentially inter alia that the dark number 104 is village land of Purana Bazar B village, which fact may be verified by the scale map available in the official records of the district administration. That in 2006, Sri T.A. Nguli, ex-finance minister Nagaland, from whom the respondent number 4 claimed ownership, sought to encroach upon the dark number 104, claiming that he was allotted the same by the government in 1986. But the villagers had prevented the encroachment, considering that his claim over the land was not supported by law. That the respondent number 4 and one Srimati Koholi Achumi, both claiming to have obtained Pata against the allotment made to Sri T.A. Nguli, encroached into the dark number 104, but the villagers on 20/2/2020 compelled them to withdraw from the land. That Srimati Koholi Achumi filed an FIR dated 21/2020 against the villagers, particularly naming Sri Vivotu Chibi and Srimati Anongla Imsong, because of which the affected villagers took up the matter with the district administration by submitting a joint complaint dated 23/1/2020, praying for a restraining order against her, and the Deputy Commissioner was pleased to issue restraining order dated 27/1/2020, directing Sri Hukavi Zimomi, advocate, husband of Srimati Koholi Achumi, to refrain from undertaking any developmental work. That the Deputy Commissioner also issued summons dated 11/2/2020 to both the parties to appear before his court on 19/2/2020 along with original documents. And as summoned, the complainants appeared through counsel with all relevant documents, and the matter is pending disposal. that Srimati Koholi Ajumi also filed a civil suit before the Court of the Civil Judge Senior Division, Dimapur, registered as civil suit number 1 of 2020, in pleading as defendants Sri Vivoto Chibi and Srimati Anongla Imsong, and the case is pending before the said learned court, that while matter stands thus, the restraining order dated 14/10/2020, that the order itself is vague and general in nature, specifying no individual or group, and the same has been issued without giving opportunity of being heard to the villagers, that the restraining order dated 14/10/2020 is unsustainable, and as such, prayed for immediate recall, revocation of the restraining order dated 14/10/2020. So, the representation stating all these were made before the Deputy Commissioner. 14. That upon receipt of the petitioner's representation dated 31/10/2020, the Deputy Commissioner Dimapur, instead of vacating the restraining order dated 14/10/2020 by notice, white number so-and-so, dated 21/10/2020, notified that the matter is sub judice and in the process of adjudication, that all parties concerned are directed to maintain status quo until the matter is disposed of, and that accordingly the restraining order dated 14/10/2020 stands. Then 15. That aggrieved, the petitioners preferred a writ petition registered as WBC number 192/2020, impugning the order dated 14/10/2020 and a notice dated 21/10/2020. And this Honorable Court, by order dated 8/12/2020, disposed of the petition with a direction to the Deputy Commissioner Dimapur to dispose of the matter concerning the land in question within a period of 2 months and to maintain strict status quo of the land till then. That in compliance, 16, that in compliance with the Honorable Court's order, the Deputy Commissioner, by order dated 22/12/2020, directed all parties to appear before him on or before 10/1/2021 with all supporting documents. Then 17, that as directed, the petitioners through counsel appear before the Deputy Commissioner Dimapur on 8/1/2021 with all relevant original documents of land allotments and pata to contest the matter. But he was asked only to submit the documents. Accordingly, the learned counsel, by letter dated 8/1/2021, submitted the documents to the Deputy Commissioner, who received the same. 18. That subsequently the Revenue cum Settlement Officer summoned the petitioners to appear before her on 25/1/2020, and as summoned, the petitioners through counsel appeared before the said officer. The hearing was conducted by the Revenue cum Settlement Officer, and the Deputy Commissioner Dimapur was not present during the entire proceeding. At the hearing, the said officer bluntly told the counsel for the petitioners that the settlement granted to D.A. Nguli is the only valid document, and the authority would not consider the allotment and pata issued in favor of the petitioners and other records of any sort. 19. That the district land survey officer also visited the spot on 8/2/2021 and asked the petitioners to produce their allotment certificates and pata. The petitioners having produced the documents before them, the said officials took photographs of the documents and left the spot. That thereafter, by impugned order number VLS 4/2007, dated 11/2/2021, the Deputy Commissioner has held that the respondent number 4 is the rightful owner of the land in question and issued restraint upon the Village Council Chairman, GPs, and members from interfering with the peaceful possession or obstructing the developmental activities carried out by the respondent number 4. A perusal of the impugned order clearly reveals that the objections raised by the petitioners in the representation dated 31/10/2020 and detailed submissions made on the basis of the record and existing law has not been dealt with by the Deputy Commissioner Dimapur, who was not present at the hearing on 25/1/2021. Not even a mention has been made about the valid pata issued the petitioners by the Deputy Commissioner himself. Question as to who has been in actual possession of the land in question was not even considered. Biasness is apparent on the face of the record in that the Deputy Commissioner Dimapur took into consideration only what appeared to him to be favoring the respondent number 4 and accordingly passing the order in his favor. So the impugned order is at Annexure B, which is at page 209. Page 209. if I may read.
Yes.
This case owes its genesis to an application having been filed by Mr. M. Long Riao to the effect that some vested individuals were causing obstruction and had illegally stopped developmental activities taking place on his land situated at Purana Bazar and is covered by Pata number 1091, Dak number 104, under Moza number 3. Thereafter, the said land, it was further stated that though the rightful owner, he was under constant threat, disturbance, harassment, and obstruction while performing developmental activities. As such, M. Longri prayed for issuing restraining order. Accordingly, this office took cognizance and issued restraining order over the said land. In the meantime, the Purana Bazar B village inhabitants appeared and contested the case. Accordingly, summon was issued and parties directed to bring original documents in support of their respective claims. On 25/1/2021, the parties appeared before the Revenue Officer Dimapur and submitted documents in support of their claims. The parties are thereafter allowed to make oral submissions. While hearing the matter between the disputing parties, it came to light that Mr. Longri had purchased a portion of land measuring an area of 34 bika 0 kata 0 lisas from Sri Kohoki Awomi by executing a sale deed, which is registered as registration number ST so and so 6918. Thereafter, mutation was carried out and Pata bearing number 1091, Dak number 104, under Moza number 3 issued in his name. Per contra, the inhabitants of Purana Bazar B village submitted that since the said land falls within Purana Bazar B village, the government has no power to issue Pata without NOC from Purana Bazar B village council. It has been clearly contested here. Further, it has been submitted that the signature appended in the sale deed bearing registration number so and so by the chairman is questionable. Furthermore, the GB submitted that the village council chairman has issued allotment to certain individuals over the said land as it is under their village jurisdiction. I have heard the submission given by the parties at length and also perused the documents filed therewith and checked the records of the case. I have come to a considered opinion that Sri Longri was issued Pata of the said land after complying with the procedure contemplated under Assam Land and Revenue Regulations 1886. The record shows that a spot verification had been conducted and notice inviting claims, objections under Section 52 of ALR published in the local daily on 9/10/2018, issue of final mutation order bearing number so and so dated 31/1/2019 and thereafter issue of land Pata book number so and so white 6/4/2019. The process of mutation is based on the face value of documents submitted therewith. And further, despite notice having been issued, no claims and objections were received from any quarters. Therefore, the process of mutation cannot be challenged at this stage when the Pata has been issued after complying with all the procedures. Further, the joint spot verification report submitted dated 10/2/2021 and the Pata number 1091 finds tallied with the record available in this office, thereby proving that the said lands is in possession of Sri Longri. It may be mentioned here that similar situation arose when the present seller Sri Kohoki Awomi purchased the said land from Srimati Sanu Nguli. When the said land was transferred into the name of Sri Kohoki Awomi, a dispute arose between Sri Kohoki Awomi and Village Council Chairman and GB's Purana Bazar P. In that case, the Deputy Commissioner Dimapur, while passing a restraining order dated 11/5/2016, observed that the land covered by Pata number so and so, measuring an area of 50 bika, is in the name of Sri Kohoki Awomi, and as such, the Village Council Chairman and GB's Purana Bazar were restrained from interfering, disturbing the peaceful occupation. The Office of the Deputy Commissioner Dimapur also issued an NOC dated 4/4/2018, certifying that Sri Kohoki Awomi has a plot of land under Dak number so and so, measuring an area of 50 bikas under Moza number so and so. Therefore, the matter having been put to rest, the same cannot be re-agitated. It is also opined that Purana Bazar B village falls within cadastral surveyed land, and hence the government has every right to issue patas for the same. On the other hand, the claim of some individuals over Longri's land based on the village allotment certificate issued by Purana Bazar B village council cannot stand ground. In this connection, it is reiterated that the said land falls under the category of cadastrally surveyed land, wherein the Land Revenue Department is the only competent authority to allot and issue Jamabandi. Reference may be made on the notice bearing so and so, dated 31/7/2002, issued by this office, banning the GBs, chairmen of village colonies from issuing patas, and further declaring the land pata issued by any GBs, chairmen of village colonies as null and void. The said notice is reproduced hereunder as I have come to the notice of the district administration that some GBs and chairmen in Dimapur district are issuing land pata, local pata to the individuals in the cadastral and non-cadastral areas. Henceforth, the GBs, chairmen, village colonies shall not issue any such land pata as there is no pata system in the village in Nagaland, other than in cadastral area to be issued by the government. Any land pata, local pata issued by any village council, GB, and chairman is hereby declared null and void and will not be accepted as a document. As regard the dispute over the signature of the chairman in the sale deed, this office is not a competent authority to determine the validity and genuinity of a sale deed or, for the matter, signature appended on it. In light of the facts and circumstances mentioned above, the office, based on records, hold that Sri Longri is the rightful owner of the land covered by Pata number 1091, Dak number 104, under Moza number 3. The Purana Bazar P Village Council Chairman, GBs, and members are hereby restrained from interfering with the peaceful possession or obstructing the developmental activities carried out by Sri Longri on the said land. Failure to comply with the instant order will invite serious legal consequences and be dealt accordingly as per law. So, aggrieved by this, I have approached this Honorable Court. Now, the main ground which I am taking is that this is village land.
The DC, by this order, has
Yes.
in fact decided the title.
Yes, title
In favor of the
in favor of the
private
yes,
respondent.
yes. So aggrieved by this.
So against that, revision can also lie.
No, Your Lordship, in the writ petition which was filed before this Honorable Court, which is now the judgment, exactly the same case arose. Exactly the same case. Even this person.
No. But there, the title was not decided. It was against eviction.
Yes, that
It was
means
against
that
eviction.
means it was already decided in favor of the other person. For that, the person who was holding the petitioner in this case was directed to evict, and the pata which is in favor of the respondent is the genuine one. That was the decision taken by the Deputy Commissioner in this case. Now here, Your Lordship, if it is village land, then the question of the Deputy Commissioner having jurisdiction to issue pata does not arise. That is my only simple case. My case is, if this is village land, then the Village Council Act applies. So here, the map prepared by the state clearly shows the land to be within the village land. So now when it is village land, the Deputy Commissioner cannot settle it, the government cannot settle the land. It now belongs to the village and its people, as per the Village Council
You also
Act.
appeared before the Deputy Commissioner.
Yes.
Yes.
We have raised that issue. This is it. This is village land. The Deputy Commissioner did not even go into all those aspects. If it is land which does not fall within the village land, then obviously the Deputy Commissioner has jurisdiction to decide. But since in this instant case it is village land, recognized as such by the government, then in that case, the Deputy Commissioner has no jurisdiction to issue any order. As simple as that. And even that allotment given to TM only, it is by the state government, is void ab initio, having no jurisdiction because it is village land. It is the village established in 1942 during the British time. Government has acknowledged it to be a traditionally established, recognized village, and map has been drawn by the government itself, demarcating the extent of the village land. So there is no dispute at all. If it is a recently established village and there is no map, then in that case, it becomes a disputed question of fact. But here in this case, the record is very clear. It was established in 1942. Government recognizes it. It is a traditionally established village, a recognized village. And the Village Council Act clearly says that even if it is government land, if it falls within the jurisdiction of the village, it is village land given to the village by the government. The Village Council Act, Your Lordship, will have a look at the Village Council
Then
Act.
what happened to that society which was
Society is
allotted the land?
it is part of the village body only. So the society, after some time, because of the infeasibility of cultivating and doing development work there, because the fact remains that during the summer season it becomes like a huge pond. Only during winter it gets dry. This area, it is a waterlogged area, and it is an admitted fact. So because of that, although the villagers were wanting to develop it, it's an expensive venture. But slowly, with the expansion of the village, villagers were interested to take portions of the land. Because of that, the village started allotting the land to the villagers. Otherwise, it is waterlogged throughout the year. It's like a marshy area only.
Yes.
So it is, the record is very clear that it is Purana Bazar village land. So once it is village land, then any kind of settlement by the government without the knowledge of the village authorities is void ab initio. We don't even need to challenge the order. The Supreme Court has clearly held that if it is if an order has been passed without jurisdiction, then in that case there is no need even to challenge it. It can be ignored. So the allotment to Tianguli in allegedly in 1986, there was no need to challenge that order also, because it is void ab initio, without jurisdiction. So the Deputy Commissioner had no jurisdiction to issue this order, and as the Honorable Single Bench in the coordinate bench of this Honorable Court has clearly held, the government cannot show that it is government land, whereas we are able to show that it is village land by the map itself, prepared by the government. So therefore, if they are aggrieved, they may approach the civil suit. But even in that case also, here it is very clear, it is village land cannot be allotted by the Deputy Commissioner. No pata can be issued by the Deputy Commissioner under the Village Council Act. Your Lordship may kindly see the Village Council Act.
Section?
I'll start from the section 3. Section 3. Section 3. Constitution. Constitution. Village means and includes an area recognized, every recognized village shall have a village council. So this village also has a village council. Explanation. Village means and includes an area recognized as a village as such by the government of Nagaland. An area, in order to be village under this act shall fulfill the following conditions, namely, A, the land in the area belong to the population of that area or given to them by the government of Nagaland. If the land in question is a government land or is land given to them by the lawful owner of the land. So if it is a government land, land falling under them, it is deemed as the village land, as given to them by the government. Here in this case, way back during the British period, it was established, the entire village was founded. Nagaland statehood came only in 1963. So, village land, deemed village land from the very beginning, but the map further solidifies that fact. The map only solidifies the fact that it is village land. So, for as a village council shall consist of members chosen by village, so they have the village council. Village council is now. I'll take your lordship to section.
Fifteen G.
Yes, yes. (15G), yes. No transfer of immovable property shall be effected without the consent of the village council. Written record of this shall be maintained by the village council. So here, all these things were the respondent number 4 was behind the back of the village. The village was not taken into confidence from the very beginning. The village had no idea. So every transaction has to be verified with the consent of the village. If it is the village itself, it is empowered with taking care of the entire village property. So here in this case, the village had the authority to issue the allotment to the petitioners, whereas in the case of the respondent, the deputy commissioner had no authority, or the state government had no authority to issue any allotment in their favor. Because this act has to apply. This is the Village Council Act which is applied throughout the state. If they are saying that it is not a village council, it is not a village, then that is a different issue. So with regard to the issuance of the pata by the deputy commissioner to the respondent number 4, or allotment grant of the land to Mr. T. Nguli way back in 1986, it was without jurisdiction. It had no jurisdiction. And in this regard, I would like to take your lordship to one apex court decision. This is 2021. AIR 2021, SC 2932. Paragraph 19.
AR 2021 SC 2932.
Yes.
Para 19.
Para 19. this at this stage, if I may read, there are 2 19s here.
Yes, at this stage.
Yes, at this stage, it may be useful to keep in mind the purport of expression void and voidable. For that, we may advert to the exposition in the case of Thurandar Prasad Singh versus Jai Prakash University and others. So and so, 2001, 6 SCC 534, which had noted the dictum of Lord Tinning in R versus Paddington Valuation Officer Pitchery Property Corporation, also in Judicial Review of Administrative Action by D. Smith, Wolf and Joel, and in Judicial Remedies and Public Law by Clive Lewis, the same read thus. 19. This question was examined by the Court of Appeal in the case of R versus Paddington, valuation officer. So and so, where the valuation list was challenged on the ground that the same was void altogether. On these facts, Lord Tinning MR laid down the law, observing at page 841 thus: it is necessary to distinguish between 2 kinds of invalidity. The one kind is where the invalidity is so grave that the lease is a nullity altogether, in which case there is no need for an order to quash it. It is automatically null and void without more ado. The other kind is when the invalidity does not make the lease void altogether but only voidable. In that case, it stands unless and until it is set aside. In the present case, the valuation lease is not and never has been a nullity. At most, the first respondent acting within his jurisdiction exercised that jurisdiction erroneously. That makes the lease voidable and not void. It remains good until it is set aside. D. Smith, Wolf and Joel, in their treatise Judicial Review of Administrative Action, so and so has summarized the concept of void and voidable as follows. Behind the simple dichotomy of void and voidable acts, invalid and valid until declared to be invalid, lurks terminological and conceptual problems of excruciating complexity. The problems arose from the premise that if an act, order, or decision is ultra-virus in the sense of outside jurisdiction, it was said to be invalid or null and void. If it is intra-virus, it was of course valid. If it is flawed by an error perpetrated within the area of authority or jurisdiction, it was usually said to be voidable, that is, valid till set aside on appeal or in the past quashed by certiorari for error of law on the face of the record. Clive Lewis, in his work Judicial Remedies in Public Law, has explained the expression void and voidable as follows. A challenge to the validity of an act may be by direct action or by way of collateral or indirect challenge. A direct action is one where the principal purpose of the action is to establish the invalidity. This will usually be by way of an application for judicial review or by use of any statutory mechanism for appeal or review. Collateral challenges arise when the invalidity is raised in the course of some other proceedings, the purpose of which is not to establish invalidity, but where questions of validity become relevant. Thus, the expression void and voidable have been the subject matter of consideration on innumerable occasions by courts. The expression void has several facets. One type of void act, transaction, decrees are those which are wholly without jurisdiction, ab initio, void, and for avoiding the same, no declaration is necessary. Law does not take any notice of the same, and it can be disregarded in collateral proceedings or otherwise. The other type of void act, example, may be transactions against a minor without being represented by a next friend. Such a transaction is a good transaction against the whole world. So far as a minor is concerned, if he decides to avoid the same and succeeds in avoiding it by taking recourse to appropriate proceeding, the transaction becomes void from the very beginning. Another type of void act may be by which is not a nullity, but for avoiding the same, a declaration has to be made. Voidable act is that which is a good act unless avoided. Example, if a suit is filed for a declaration that a document is fraudulent and or forged and fabricated, it is voidable as the apparent state of affairs is the real state of affairs, and a party who alleges otherwise is obliged to prove it. If it is proved that a document is forged and fabricated and a declaration to that effect is given, a transaction becomes void from the very beginning. There may be a voidable transaction which is required to be set aside, and the same is avoided from the day it is so set aside, and not any day prior to it. In case where legal effect of a document cannot be taken away without setting aside the same, it cannot be treated to be void, but would be obviously voidable. It is well established that, Your Lordship, the 20 is also relevant. It is with regard to void contracts, but now here, void, something which is void is totally an order which is passed without jurisdiction. If it is without jurisdiction, there is no need to even challenge it. That is the position. You just ignore it. Here in this case, it is village land. Once it is village land, then the deputy commissioner or even the government officers have no power, no jurisdiction to allot it to some other person. So the allotment to Tianguli way back in 1986, so-called way back in 1985, is a nullity without jurisdiction. So there is no even challenging that is not necessary as per the law because it is without jurisdiction. That is my simple case. So if they should file a suit before the civil court, since this is a dispute, now this is private land between private individuals. If any of the parties take it to before the civil court, this ground will be taken before the original civil court. But my whole submission here is that this is land belonging to the village, which is clearly on record, and even the law is in my favor. So the deputy commissioner had no jurisdiction to pass that impugned order, and the judgment which I have submitted before this court, the facts are exactly same. Facts are same, only that the parties are different. Here in this case, only 2 individuals are involved. Here in this case, 1 individual and the petitioners are involved. Because their rights are being sought to be taken away by the respondent number 4. And the deputy commissioner has held that the land is his. So if he is aggrieved, he may approach the civil court. But since this is land which has been under our possession and he has encroached onto it, the deputy commissioner had no jurisdiction to pass this order. So the same ratio that has been applied in the earlier writ petition may be applied. The coordinate bench's decision is still standing today. The government has not taken any steps to claim that it is their land. In that case, the matter has ended there. So now the state government cannot hear in this case, when they have not been able to prove that it is their land, they cannot take the stand again in this case also.
But in this matter, in the other WPC 40, the deputy commissioner had not adjudicated, parties did not appear before him, and it was
no,
not
Your Lordship, if Your Lordship will
as
read
it was
it.
done in this case.
Yes, if Your Lordship will read it. It is more or less essentially the same. Whether the deputy commissioner could, yes, but my case is this. Whether the deputy commissioner has jurisdiction to even take up this case or not. That is my case, my issue.
Okay, then next.
So my only case is deputy commissioner, whether it had jurisdiction even to take up the case and dispose it off in this manner. That is my case. And since it is village land, he has no jurisdiction over the village. Village land to decide the matter and in favor of one party. And this is a case where a complaint was given before the deputy commissioner, my right over the land has been encroached, kindly evict them. That was the letter issue written by the village, by the respondent number 4. If Your Lordship may go here, go to that letter, which is annexed here. Annexure I-2, page 180. Sir, the undersigned is obliged to submit the following facts and circumstances for your perusal and necessary prompt steps, please. That I, Sri M. Longri Au, is the rightful and absolute owner of the aforementioned plot of land. That I am the patta holder of the aforementioned plot of land, which I have acquired from Sri Kuhoki Aomi, white registered sale deed bearing registration number so and so. My hard-earned money and transferred the same into my name, white mutation dated 31st January 2019. That the aforesaid land being situated in a swamp-like and waterlogged area, I have started filling out the plot with earth. However, some vested individuals are causing obstruction and has illegally stopped any work from progressing. That at the time of filing this prayer, 15 numbers of timber trucks and 1 JCB has been illegally stopped from undertaking any work in my plot of land, causing huge financial losses and undue obstruction. That this unscrupulous man has been causing undue obstruction and illegally disrupting the peaceful enjoyment and ownership of the said land. That despite being the rightful owner of the aforementioned plot of land, the undersigned is unable to undertake any further development work due to the constant illegal trade disturbances, harassment, and obstruction. It is under these unsolicited circumstances I am obliged to seek for your urgent intervention and humbly beg for the above cited subject. That the undersigned is seeking your intervention as last resort and have exhausted all other rational steps in my capacity to peacefully develop and enjoy my land. That issuing restraining orders against the illegal obstruction will be in the interest of justice and fair play, and in the absence of any restraint from your esteemed office, the undersigned will incur grave injustice and undue loss damages. It is only a prayer for restraining order.
So on the basis of this...
On the basis of this, the impugned judgment, the impugned order has been passed by the Deputy Commissioner. It is not a suit filed before the Deputy Commissioner.
Yes.
So the Deputy Commissioner had no jurisdiction to entertain this case. It was his duty to direct the petitioner to approach the appropriate court of law, because it is not within his jurisdiction, it is within the jurisdiction of the village. If the village is saying that it is not yours, you file a suit, but not before me, because it is not my village land. That only the Deputy Commissioner ought to have done. But here he has decided the entire case, he has decided, gone into marriage according to his own preference, and then he has passed this order, which was not prayed by the respondent. He prayed only a restraining order. So it is a field case where this Honorable Court may apply the ratio which was passed in the analogous case by the coordinate bench of this court, because it ought to be. When it still stands today, it is good law, Your Lordship. Orders or judgments passed by the coordinate bench should be, so long as it stands, should be applied by the court. That the judgment is also there, Your Lordship.
If it's on the same facts and circumstances, there's no dispute about that.
Yes.
We'll have to see whether
So it is same. In that case also, a restraining order was sought for the Deputy Commissioner pass order. Here also, in this case also, application for restraining order was made. The Deputy Commissioner has passed the order. Maybe the order may vary slightly, but the fact is very same here also. And the TC had no jurisdiction. That is my only case. If it is government land, then TC has jurisdiction. But if it is village land, then TC has no jurisdiction to take up any such cases. Whether he may have taken it up under the Assam Land and Revenue Regulations, but the Assam Land and Regulations does not apply in this case because it is village land. That is my humble submission before this Honorable Court.
should we continue today or Thursday?
Thursday, Your Lordship,
Thursday,
better.
I
Yes.
think
We
that's
will not be
better.
able to conclude today, Your
Yes.
Lordship.
This is my next judge. Yeah. Totally, and beneath that, no? That's it.
In fact, Your Lordship, I'm extremely sorry for the inconveniences caused to this Honorable Court as well as to two of my senior friends today, Your Lordship. But thank you so much for accommodating me, Your Lord.
Worship, yes, man of good the whole day. He went for Barakana. He attended one of the staff was married.
Oh, for that you sought time. Not fair.
They went and had Barakana.
But I prayed for all of you, madam.
Actually, I adjourned it very unwillingly because I've been traveling since Friday,
Oh no.
going up and down and all by road only. So I'm very tired and not recovering.
This morning, in fact, I requested my colleague, why don't you just make it only? But I think he wanted to torture us.
In fact,
Anyway, we will try to complete it on Thursday then. Heard to Learners Council for the petitioner, Mr. Tongpat Pongoner. The learned councils for the respondents are present. The matter is part heard. List again on 16 then as a part heard matter.
I'm deeply grateful, madam.